So at some point in time, I purchased a book regarding securitization law. It was published in 1995. I used to have a reference point for 1995 as being the first year I attempted to go to college after I graduated from high school. But it appears that, at least specifically here in the state of Texas, there were very substantial changes that ended up occurring when it came to the general fund for the state of Texas. I've already posted another video where I provide information from a primary source document that I understand is not around anymore. It makes me wonder if what I saw at the library is comparable to what is part of why that information is not available, where they will take actual books and they'll destroy them, or they'll remove them from the public realm. Did they take the primary source information about what the law was at the time and destroy it, with an understanding that unless you were a specific kind of insider and had your own private collection, you wouldn't be able to track it? It's not in the electronic records. Where do they keep the archives for the retired indices? Is it part of the official state archive? Well, if they're required by law to put information that would be considered the public record online in order to be electronically accessible, and they're repeatedly altering the information that's available online in relationship to the official written record that are in places like libraries, including official law libraries for educational institutions, or for those that are identified as being eligible for access to a specialty library, like, for instance, the law library across the street from the Supreme Court of Texas facilities, where you have primary source documents in the form of books that are the official record that say something in the books different from what you find in line, kind of like Venable and the original Trip. And yes, I'm going there because that's exactly what I'm talking about. You can't find that information online. It was in a very specific part of a very specific library. It would have been the first response of the insurance sector when it came to 9/11. I haven't been able to find that book anywhere except that place in the official library for the Supreme Court of Texas. Now, I have something here, and I'm just going to reflect on time, dates, understanding. Yesterday was a very important day. So yesterday and the day before, I wrote a series of outlines regarding what would be my follow-up to efforts associated with cases and investigations I've been involved with. And I've actually got what are not only follow-ups to both my cases, including in the attendant jurisdictions and the specific outline in the process, but I have, which I have two of, that were finished before 9 o'clock a.m. on August 30th, 2021. One of which starts specifically with cases I filed in Texas beginning in 2017. And I have the 4-page outline, including what I've already identified as the appropriate case citations and pieces of work that I've compiled in the course of the last 2 to 4 years that would be put into it. So the work's already been done. It's a matter of compilation and formal formatting. And then there was another one that begins with a follow-up response from 2018 regarding a writ a quo warranto that was then referred to the Supreme Court of the United States, and also responds to accusations that were levied in other efforts to contact the Supreme Court of the United States, specifically recently concerning a 13th Amendment argument. But what started with a question regarding under what authority was what was evident in the federal budget process outlined in 2017 confirmed, under what authority was it issued? Because the accusation was that it was demonstrative of a pattern of racketeering activity, and the distinction between what creates it and establishes it as crime as opposed to what establishes it as some form of scheme that would be legitimately engaged in some sort of risk-based approach to federal budgeting, has to do with application of the law in following through on that which was represented as being the intent and the promise at its inception. Very basic matter of contract law, right? So both of these necessarily discuss contract law, which also includes mental capacity to engage a contract, which is very important when one considers Second Amendment. Now, part of my 13th Amendment argument is also a Second Amendment argument. And I have tried several times to refer to a specific case discussing the Second Amendment from a perspective that I understand provides a very substantial foundation for supporting my argument. The problem is, there were factors associated with that case that thus far have not been disclosed. And that somebody else took it upon themselves to engage in a process where they were entitled to due process, and they were entitled to a remedy before the courts, and they were entitled to even present arguments and to present evidence in support of a claim, including a claim that would have a foundation in setting precedents that would be evaluated in consideration of criminal convictions for the future. It was not disclosed to me at the time that the situation I was in was going on concurrent to these efforts, or that people that I was working with at the time had a vested interest in the outcome of that specific case. And part of the vested interest they have is an understanding that there were competing interests, including competing commercial interests that necessarily will have to address 13th Amendment arguments and be addressed through the 13th Amendment arguments. And so we're at this point in time where I've revisited that case, specifically, the opinion in that case 3 times. I have a record of 2 times, even though they might be muted. The other time, well, they wanted to erase the entire record. October of 2020, I provided an extensive review of the case concerning District of Columbia versus Heller. I have here what were the written notes. See, as soon as I recorded it, somebody deleted the voice files. So there was no actual verbal record. I spent more than 2 hours, 2.5 hours reviewing the case that day. And in the course of reviewing it, I made very, very detailed, very comprehensive analyses, almost line by line, of the dissenting opinion that was provided in that case by Justice Scalia. You know, as soon as I was finished, it was deleted. Somebody took it. And now they've taken the record of it. But in the course of that, I immediately after I finished, wrote down, to the best of my recollection, the general argument of that particular evaluation. Now, the problem is this process of securitization. Apparently, what I did the first time was considered to be of the kind of quality that it would provide a foundation for establishing a kind of underlying support. And so when I attempted to re-engage and to do this part of it, well, what ended up happening is it had a different character. It had a different jurisdiction. It had a different amendment that it was drawing on. That it was using a Second Amendment argument is an underlying securitization in regards to an attempt to promulgate another kind of argument invoking another constitutional amendment. Now, I'd been witness to this before. In April of 2020. So it was in that manner that when I was exposed to the process myself, I had a little bit of an understanding of what was ongoing. I have that available right here. I don't have any intention of allowing it to be used as some sort of securitization where somebody else can say that they need to draw on support from an underlying that is supposed to be anonymous, it's supposed to be off the record, it's supposed to have a particular quality and a particular value, but ultimately is merely there to provide structural support to some other argument that for whatever reason has been determined to have a particular kind of political capital that is preferred by those who were not contracted with to access the argument, first of all, and second of all, would not have been the constituency or the cause to which I would have provided that kind of support. And again, it goes into considerations of mental capacity to engage a contract, including people that have hedged on being able to establish a situation where they can have people alleged to have been identified as having a mental health problem or have been diagnosed with some sort of psychiatric disorder, put into a database where they are banned from owning a weapon, including weapons that their medical treatment and diagnosis was used in developing. This gets to the essence of my Second Amendment argument supporting my 13th Amendment argument. It's been stolen 3 times. The results of the most recent one, one of the ones from November 2020, I have an outline I could very easily provide it at the appropriate quality. But what I also have here is this affidavit that I printed yesterday. Presumably, I am supposed to go to a proceeding involving a justice of the peace, a justice court. But my understanding is some of the contexts under which I am being summoned are themselves not legally binding. Now, I understand that what I produced here is actually quality. There's no typos. The formatting is perfect. It just happened that way. That's the quality it is. And because of the way it was established, this is actually something that would be available for bonding. But here's a problem. I understand the actual proceeding that is attempting to invoke this, or request this, or demand this, is under fraudulent pretenses, and is itself illegal, and is basically not only a form of kickback, but a promise that I would be bonding myself, I would be agreeing to make a bond with a legal proceeding I understand to be under completely fraudulent pretenses. And yet, if I don't establish the terms of the bond in this completely fraudulent circumstance, and somebody else has already determined, oh, without bond, we're just going to do what we've been doing. You see, the truth of the matter is, by now, there should have already been provided publicly a process whereby the last 3 attorneys general would describe publicly what they were going to do in order to provide the people with an audit of all bonds that they approved while they were in the performance of the role of the attorney general. They did not do such a thing. There are more than one process that whereby they can do that. If there are specific interests, for instance, they feel that they need to protect, especially during this time frame. And as a matter of fact, especially during this time frame, there's specific requirements under the Texas government code that they do exactly what was requested less than 2 weeks ago, or rather, what was understood to be necessary less than 2 weeks ago. They failed to do that. In the course of that, I'm being summoned into a fraudulent legal proceeding, whereby if I don't issue the foundational documentation for what the bond is going to be myself, somebody else is going to do it. And in the meantime, they still are, right? The understanding is, regardless of what the character and the quality of this is, regardless of what the veracity is, which I assure you every single thing in here is 100% accurate, regardless of that, well, they've already toxed the deal. It's supposed to be disposed of. They'll take the affidavit, they'll take the bond, but they're not going to do anything close to administer justice, and I know that. They're not even the appropriate forum through which to do so, right? And yet, all of this is what was needed. All of this was needed before 10 a.m. yesterday morning. But I can't allow, at this point in time, for me to follow through on taking those components and assembling them into a case, taking my own responses and reflections on reading opinions provided in regards to precedents regarding the kind of arguments I'm attempting to make, going through and specifying the specific charges in the indictment, which I've already done the foundational research, including in connection with what I've already put into evidence. It just merely needs to be organized and appropriately labeled for the exhibit number as it correlates to the actual statement of facts in order to get the actual text of and the composition of the actual official indictment. I can't even do that labor during this time frame because I understand that then somebody would want to try to claim that that would be that which they should have access to under these completely fraudulent and illegal contexts. Now, this has been going on for years. And what was done that would have provided an actual economic event to allow for a particular kind of security in the moment that could have accrued has been intentionally sabotaged because there's been a misrepresentation that another process has actually been ongoing that has had other priorities. And I am not about to be put in another position where, again, I'm supposed to be leaned on to produce things at this quality and with this level of risk that can merely be obscured under the auspices of some sort of insurance paradigm connected to fraudulent securitization supporting other kinds of economic events, including in association with alleged constitutional arguments or alleged legal considerations that do not actually meet the needs of the people. This is in multiple contexts. There are judges and lawyers all over this country, and apparently the world, honestly, that are not responding to the needs of the people. What they're doing is they're trying to provide some sort of security moment, some moment of intersection with a particular kind of economic event coded into other ongoing economic processes in order to secure assets that the people identified as having ownership or controlling interest in those assets by law, by constitutional consideration, have absolutely no just cause claim and no real actual ownership. They're not eligible for ownership. You can't say it's a derivative. It's not. It's fraud. It's a complete misrepresentation. We've had more than 200 years, 250 years, where these precedents have already been set. Wars, including civil wars, were already fought. Allegedly, there were treaties established to broker peace as a response to the bloodshed that happened as a result of people saying, you do not get to use me and my family and my people as your property. And then say, we're responsible for paying the taxes on your property, paying for the cleanup of what you do to your property. It's 250 years of precedent in this regard. Unfortunately, that's where the default is, insofar as this is allowed to be maintained as status quo. And until you, including all of you that are availed of the security features associated with this particular kind of exploitation, until you take responsibility for that, including in disgorging me personally from any of your illegal or illicit interest, whether it be weapons development, whether it be some alleged energy production and distribution, whether it be political risk insurance, because apparently you're not capable of engaging in analysis of important state matters without exploiting other people, without attribution. Even if you're talking about development of products associated with the biomed sector that are presumably supposed to provide somebody with relief, or in the course of some legal proceeding where somebody else believes they're due restitution, including in exposure to a particular kind of character that reminds them of a culture or paradigm from which they were dispossessed. All of those other things, unfortunately, as important as they might be, have been engaged through and under fraudulent pretenses the entire time you've tried to maintain this charade. And I cannot give you better marketing. I cannot change the underlying. It's not supposed to be an underlying. You were supposed to have to deal with it. You were supposed to confront your accuser. Insofar as there was any crime or any obligation that I had, you were required to confront me. Or you were required to provide me with an appropriate notice and verification of why you won't confront me and what you would be doing as an alternative. You've done no such thing. And we're going on more than 5 years.